Now we have a very seminar, and we have the honor to have Dr. Professor DORIS FORSTER, who is a professor at the University of Genève. We have done many things over time, because we have many common interests. This is the in fact, he is now very young, about the German system, automated and so we have the beginning here, it's really the first say some ways what the system which is required a very interesting model. So here four is has a presentation which will be there and also documented possible to share with the speaker. And thank you very, very much. Per chi invece diciamo per tutti in italiano, come Doris sa benissimo tantissime lingue, anche l'italiano, la ringrazio davvero tanto perché lei è stata sempre ospite graditissima qui a Bologna e noi poi siamo andati recentemente a trovarla nella sua bellissima Università di Ginevra e speriamo di averla anche qui presto. Oggi siamo solo in collegamento, ma dopo vedremo la bellissima Sala delle Arti che conosci e quindi ti cedo subito la parola, ti ringrazio molto e ci mettiamo ad ascoltare questa interessantissima legge tedesca che per noi è un grande modello da studiare e seguire per le nostre pure discipline che avremo qua. Grazie.
Buongiorno a tutti, grazie mille per l'invitazione a parlare oggi qui a Ginevra. Io sono a Ginevra, sì, ma thanks to new technologies, I can also talk to you in Bologna today. Just to be assured, can you hear me? Is it okay with the microphone? Okay, and then I have prepared my slides. Do you see my slides? No? Do you see them now? Yes? Still not? Ah, now it works? Okay, sorry, it was 2 clicks, not only one. Okay. So now okay. So as you can see on this photo, automatic driving or driverless cars has been a dream of mankind since quite a long time. When I was preparing the lecture for today, I wonder how new technologies could help me to prepare my lectures. So what did I do? I used ChatGPT. Why not letting create a short story about driverless cars by ChatGPT to capture your interest regarding ethical dilemmas and responsibility? So this is my result. I asked ChatGPT, let's dive into crafting a captivating short story. Can you start by asking me what my favorite genre is and a theme or element I'd like included? What did ChatGPT answer? Absolutely. What's your favorite genre for this short story? And is there a particular theme or element you'd like to see woven into the narrative? I said, can you make a short story about autonomous driving? ChatGPT, certainly. Autonomous driving is a fascinating subject. Are there any specific aspects or themes related to autonomous driving that you'd like to explore in the story? I said, accidents and responsibility. Great choice. The theme of accidents and responsibility in the context of autonomous driving can lead to a compelling narrative. Let's craft a story about these themes. So you can see that ChatGPT likes our subject, and now look at the result. Shadows of doubt. In a bustling metropolis where autonomous vehicles weave through the streets with precision, the lines between blame and circumstance blur in the aftermath of a tragic collision. Meyer is a seasoned detective with a penchant for unraveling mysteries. When a fatal accident involving an autonomous taxi and a pedestrian rocks the city, Meyer is thrust into a web of conflicting testimonies and hidden agendas. As Meyer delves deeper into the case, she encounters Jake, the distraught driver of the autonomous taxi. Jake vehemently denies any wrongdoing, insisting that the vehicle's sensors failed to detect the pedestrian darting into the road at the last moment. Simultaneously, Meyer crosses paths with Dr. Eva Thompson, a renowned AE researcher who specializes in autonomous vehicle technology. Dr. Thompson's testimony paints a different picture, suggesting that the taxi software was operating within acceptable parameters and human error may have been a contributing factor. Caught between Jake's disparate pleas and Dr. Thompson's scientific analysis, Meyer finds herself navigating a maze of conflicting evidence and hidden agendas. With each revelation, the truth becomes more elusive and the shadows of doubt deepen. Meanwhile, the city grapples with the implications of the accident, sparking heated debates about ethical implications of autonomous technology. As Meyer races against time to uncover the truth, she finds herself confronting uncomfortable truths about the intersection of technology and humanity. In the end, Shadows of Doubt serves as a poignant exploration of accountability in an age of automation where the lines between responsibility and circumstances are blurred and the pursuit of justice is shrouded in ambiguity. What a very nice read if you like novels. But if you're a jurist, you're a little bit in doubt because this story is not really interesting for a jurist because we don't know about the damage. Who are the victims? Which things are crossed? Which damage needs to be compensated? So I asked ChatGPT again, how did the accident happen? Who were the victims? Any damages? So ChatGPT added this element. In Shadows of Doubt, the accident unfolds amid the bustling streets of the city on a rainy evening. The victim is a young woman named Sarah, a recent college graduate with a bright future ahead. Sarah, lost in thought as she rushes to catch a bus, steps out from behind a parked vehicle and into the path of an autonomous taxi. The autonomous taxi, operated by Jack, a seasoned driver who has entrusted his livelihood to the technology, detects Sarah's sudden movement but struggles to react swiftly due to the adverse weather conditions. Despite Jake's best efforts to maneuver the vehicle away from Sarah, a tragic collision occurs. Interesting, but now we have a new problem with this ChatGPT story. So, what question will I ask now, ChatGPT? Maybe you can already imagine. I don't understand. If it is an autonomous car, why Jack the driver needed to react and maneuver the vehicle? ChatGPT, you're absolutely right. I apologize for the confusion. Let's correct it. So in the context of an autonomous vehicle, check wouldn't need to manually react and maneuver the vehicle, as the car systems are designed to handle such a situation. Let's adjust the scenario. So here we have the final story of our accident with the autonomous taxi. The victim is a young woman named Sarah, a recent college graduate with a bright future ahead. Sarah, lost in thought as she rushes to catch a bus, steps out from behind a parked vehicle and into the path of an autonomous taxi. The autonomous taxi, guided by its sophisticated AI system, detects Sarah's sudden movement but struggles to react swiftly due to the adverse weather conditions and a temporary malfunction in its sensors. Despite the vehicle's attempts to avoid a collision, a tragic accident occurs. The impact sends shockwaves through the city, leaving Sarah critically injured and the occupants of the autonomous taxi shaken. As emergency responders rush to the scene, the true extent of the damage becomes apparent. Sarah sustains severe injuries, leaving her fighting for her life in the intensive care unit of a nearby hospital. Meanwhile, the autonomous taxi bears significant damage, its sleek exterior marred by the collision. In the aftermath of the accident, questions about who bears responsibility for the tragedy. Was it a failure of the autonomous technology, the result of unforeseen circumstances, or simply an unfortunate twist of fate? As Maya delves into the intricacies of the case, she finds herself grappling with the complexity of assigning blame in a world where the boundaries between man and machine blur. So, after some attempts, ChatGPT gave me this nice short story, which actually underlines the main points when it comes to autonomous driving and responsibility. Who is responsible? Is it the driver, the keeper? What is the reason for the accident? Is there a problem in the programmation? What is the role of the engineers behind? But what we can also see in the story are the ethical questions and these illusions people often make when it comes to new technologies and artificial intelligence, that we see a new world where the boundaries between man and machine blur. And this story actually brings me to the points I want to discuss with you today. I want to start with a reality check, myth and reality. Do we really live in a new world where the boundaries between man and machine blur? To answer this question, we will also have a look at the historical and philosophical aspects of liability. What is the role of the human in this world of new technologies? And then I will present you the main points of the new German law on autonomous driving, and I will focus on two principal points. The first point is the situation of dilemma, that is unavoidable accidents, and the question of liability. With the new technologies, the responsibility might shift. We will, for this reason, also ask the question about product liability. What is the role of product liability when it comes to autonomous driving? And we will also look at propositions for liability for artificial intelligence in general on the European level. And in the end, we will also have a quick look at the legal situation in Switzerland and China. So let's start with the ethical dimension. We saw in our short story that ChatGPT was ending the story with the phrase where the boundaries between man and machine blur. Are machines really humans? Is there a moment where we can differentiate machines from human beings? We imagine the new technologies to change our world. On the one side, we can see a huge euphoria. Computers that are smarter than humans, the new technologies who can prevent the climate crisis, etc. But on the same time, we also see huge risks which lead to apocalypse. This is an existential risk. Artificial intelligence could lead to an extinction, experts warn. So the difference between euphoria and apocalypse couldn't be any bigger. But actually, I would like to reassure you, because this is nothing new, it's actually an old myth. About which myth I'm talking. Since antiquity, mankind was dreaming about creating life, as God would do. Here you see Prometheus, who was giving birth, life to this man of clay. He was making them think and act. He did that without the consent of God, why he was punished severely after it. The next example is Mary Shelley, who invented in 1816 in this nice little villa here in Geneva. Here you can see the Lac Léman, the Geneva League, the figure of Frankenstein, the modern Prometheus. Frankenstein is also the creation of a human, a young doctor who created this artificial life. And again, we see that this artificial life turned himself against human when he was killing this child. Sometimes people refer to Frankenstein as the invention of artificial intelligence. When we talk about robots, we also can ask the question, where do robots come from? Who and where and by whom were they created? And robots is actually a Czech word, and it was in this theater play from 1920 where Karel Čapek used this word for these figures. These were also creations who were created to work, and the robots in the end, they also rebelled against their creator, which you can see here in the middle, and tried to kill him. So what we can see in all this drama is that human beings are trying to create life. And something of this myth we can see nowadays when we talk about artificial intelligence. It's again the human being who wants to create artificial life. And when we see the headlines about our enthusiasm, but at the same time the fear, we could state that the myth is just reloaded. Why is this myth reloaded? The narrative of mankind as creator of human life or artificial life is repeated again and again. But robots or any other machines are not human beings. They just imitate humans' behavior, and this imitation is controlled by artificial intelligence, by algorithms, with other words, by mathematics. So artificial intelligence, machines, is created by humans and depends on humans. Robots, they would not create anything. They are not human beings because they don't have the intentions, the emotions, and empathy as humans would have. So robots are not humans and engineers are not gods. This fundamental basic principle is important for us when we talk about law and responsibility today. The idea of humanism was created in antiquity, and the idea is that only the human being is autonomous. Autonomous is a Greek word which actually means auto, self, nomos, law. So only the human being is autonomous in the sense that the human being can give him laws. But he cannot transfer this autonomy to something else because machines, they cannot give them their own laws. Machine would always act in the fields of possibility of their programmation. And behind the programmation are the human intentions. And this is also the reason why in the end, the human being will be responsible for the acting of the machines. To give you a source of antiquity, there's a very nice source of Seneca, who already in antiquity underlined why the human being is unique and why the human being is responsible for his acting. Here it says, what is the best thing about human beings? His reason, which makes him king of the animals and second only to the gods. This perfected reason is therefore man's own good. Everything else he has in common with beasts and plants. So reason, here you can see in the Latin original ratio, is only owned by humans. Animals don't have reasons. And this difference, the reason, the human reason, explains the special role of humans in our world. This philosophical reason was also implanted in the law of responsibility in Roman times. Of course, there were no machines, so this was not a source we could find in the Roman law. But there are similar scenarios. For example, if an animal causes a damage, who will be responsible for the damage an animal has caused? And here we can read in the digest, animal harm, the Latin word is pauperies, is damage caused without the perpetrator having committed an injustice. Indeed, an animal cannot act unjustly as it has no reason to do so. So if you read the Latin text, pauperis is damnum sine injuria facientes datum, nec enim potest animal injuria fecisse quod sensu caret. So before we have seen only humans have reason, animals, they don't have reason, so they can't do injustice, and in a consequence, they are not responsible for what they are doing. Now you might say, okay, this is all old. It's 2000 years old. We are living in a new world. Is this still important for us? Well, at least when you have a look at the famous journal Nature, which is one of the most journals in science, here they make a clear reference to the Roman law. They say in 2018, Romans would have denied robots legal personhood. What is the background? In 2017, the European Parliament came with a proposition that robots actually would be responsible for the harm they cause. And the outcry was loud because this idea was not accepted. It was not accepted by lawyers, but also in the world of science. So AI can't be responsible for the damage it has caused. So also in a case of an accident, the car itself won't be responsible. Let's come back to the 21st century and the idea of digital humanism. What is the role of the human being in the 21st century? The human being still has a central role and does need to have the central role in the 21st century of the new technologies. According to this philosophic idea, the human being is still ethical and legally responsible. But the human being is also protected. The human dignity may not be at risk. So let's have a look on the new German law on automatic driving, and if this is an example of digital humanism in the 21st century. This law from 2021 applies for cars on the level 4. So level 4 means that these cars are officially driverless in certain environments. The law allows autonomous, or to be more correct, automatic driving in a limited geographical field. So a perfect example would be the so-called people mover. For example, that a minibus takes the persons from the place A to B. There is no driver in the car, but what it is needed is a supervision. So like someone who is in a control tower and controls the car remotely. So if there is an incident or another problem, the supervisor can control the car remotely. So what is special about this law? It's not only for tests, it's really for cars who are allowed to drive on the streets, and it's level 4. We have seen other examples for level 3, but this is really for level 4. One point which is special in the German law is the question of dilemmas, the famous tramway dilemma. What is the famous tramway dilemma? This is actually the moment when an accident can't be avoided. Dilemma means that a person is in a situation where the person has to make a choice between two alternatives, and either alternative the person takes, it won't be a good choice, because there's always an ethical mistake in the decision the person has taken. So when it comes to car, you can imagine the car is rolling on the street, and there is a group of persons crossing the road. If the car goes directly, there will be 5 victims. If the car makes a little movement, there will be 1 victim. But the car is so fast, it can't stop. There is no possibility that there won't be 0 victims. So the tragic choice is between 5 victims or only 1 victim. There is an analog version of this problem, the so-called tramway dilemma. This is a case which has been discussed since nearly 100 years in criminal law. We have a similar, not the same problem, but a similar problem when it comes to train or trams. In this case, we see here the train. If the train goes on, there will be 5 victims, and this person here has the possibility to change the way of the train, that there will be only 1 victim. Now we can ask the question, if the person changes the way of the tram, there will be only 1 victim and not 5. But still the person is responsible for the death of this person. And here, in general, according to the German legal solution, the person here can be excused. There is no fault in the sense for this life, because 1 person is less than 5, and you also need to take into account that the person here is suffering from an enormous situation of stress, and the person was trying to avoid a bigger harm for the other 5 victims. So in this situation, you could actually say that the person who has changed the way of the tram won't be condemned for the death of this person. But can we transfer the same ideas to the automatic driving? Can we say that the engineer who is doing the programmation of the car has the right to say that in a case of avoidable accidents, always the choice can be made that only a fewer number of victims is killed and not the higher number of victims? And here the German legislator found a very interesting solution. First of all, the legislature said, this is a tragic choice. This choice cannot be left to the programmation of the car. According to the German law, it must be a human person in the moment of the accident who makes the choice. If you read the text in the law, it's the Article 1F, which says technical supervision of a motor vehicle is the responsibility to evaluate an alternative driving maneuver and to release the motor vehicle for this purpose in accordance with Article if the vehicle system informs him visually, acoustically, or in an otherwise perceptible manner. So why this decision, which sounds a little bit complicated? How is it possible in the real life that the supervisor who sits in his control tower makes a decision on the spot? And why is it necessary? Why we can't leave this decision to the engineer who is doing the programmation of the car? One reason is if the engineer could make the decision, the dignity of the victims would be hurt. Because when the engineer is doing his programmation, the potential victims, they are not identified. He does not know who is the victim who will be killed. And also at the moment of the programmation, the engineer, he's not in the same situation of stress as we see it in the analog version. In the analog version, the person who is changing the way of the tram, he knows who are the victims. They are identified. He knows if his mother, his wife is in the group of the victims or not. And all these elements, the concrete elements of the individual case, have to be considered when doing the tragic choice. And the engineer who's doing the programmation, he does not have this information yet. And still, it's important that a human being takes the decision and not the codes of the programmation. So this is the result the German legislature found it after long consultation of an ethical commission who was discussing all these points. So this was the first point I wanted to highlight of the new law. And now the second important question, the question of responsibility. Who is responsible in the event of an accident? There are different possibilities. We can think about the car owner or keeper. We could think about the producer of the software or the car, if there is a problem with the programmation. And what about the technical supervision, the person who is sitting in a control tower? If we look at the German law, the German name is Straßenverkehrsgesetz, we find the general rule that the keeper, der Halter, is responsible for accidents. If a person is killed, the body or health of a person is injured or property is damaged during the operation of a motor vehicle, the keeper is obliged to compensate the injured party for the resulting damage. So fault is not a condition, it's a strict liability. What does keeper mean? Keeper is not the owner, but it is the person who is in charge of the car, like the person who pays the bills, etc. And here we can't see any, this is the general rule, and it was actually not changed with the new law on highly automated cars in 2021. The only thing we can see here which has changed is the sum of the maximal liability. For the automated cars, it's 10 million. For others, it's only 5 million. So, but the idea that the keeper is responsible also for automatic driving is still there. It was not changed. What is new with the new car and automated cars? That we now have the technical supervisor who is sitting in the control tower. Is there any responsibility for this person? There is no specific provision for a strict liability for this person or anything like that. But we still can go back to the general norms of tort law. So, but this is not a strict liability. This always has the fault of the person as a condition. As there is no driver in the driverless car, we can't ask for the responsibility of the driver. And this actually brings me to the next point. What about product liability? In our nice short story from ChatGPT, we have seen that maybe there was a problem with the software. Can we hold the producer of the software accountable? In the European law, the European legislator was always very attentive about product liability. Already back in 1985, there was this famous European directive on product liability, which the European Union implemented to protect consumers. And in this case of product liability, there is a strict liability of the producer in the case of defect. ENRICO is a very huge expert on product liability, so I'm talking under his control. But here are the most important conditions for the product liability. First of all, you need a product. Normally, these are tangible things which are sold on a market, and you need a defect. When is a product, when is there a defect? There, the directive says if the product doesn't meet the expected level of safety. So here you also have a wide field of interpretation. Which safety can you expect or not? Can you expect from an automated car that there won't be any accidents anymore? And another important point is that the defect must be present at the moment when the product was placed on the market. This means if the product is placed on the market and the defect will be created only 2 years after, there won't be a case of product liability because the defect wasn't there when the product was placed on the market. So these are the conditions, the main conditions of the European Directive on Product Liability in 1985. Does this product liability directive help us with our automatic car? So if we think there was really a problem with the software, why the car hit Sarah, would the producer of the software be responsible? And here we have several problems. First of all, according to the definition of product from 1985, it's only tangible goods. Software was not meant to be included. It was 1985, so the ideas of cloud, etc., weren't that present. At that time, do you remember CD-ROMs? Like if you had a software, it was always on a disk. So this was still a different world back in 1985. And then we have another problem. Softwares, they always have updates. And if there is a problem, a defect because of an update, this will be at a later moment than the moment when the product was put on the market. So if there are defects because of an update, this is also a reason why the product liability would not hold the producer responsible. And then nowadays, we also have damage because of the loss of personal data. This is also something which is not really implemented in the product directive from 1985. And another big problem is the question of burden of proof. When it comes to software, how can you prove that there was a defect and that this defect caused the harm? Like if you have an autonomous car and there is a software problem, you really need to be an expert to have all this information and to understand what actually happens. And this is for the victim not really possible. So for these reasons, in 2022, a reform plan on the EU level was published. First of all, the definition of product is larger. Softwares and other intangible goods will be included according to this proposition. It's only a proposition yet. And also the timing of the defect was addressed as an issue. It was reformulated that also later updates can present a defect, which makes the producer liable. And the questions about damages because of corruption, loss, etc. of data was addressed. There should also be compensation for this kind of damages according to the reform plan. And to help the victim, the producer is obliged to disclose evidence when it comes to the defect and causation, etc. And also rules to ease the burden of proof for the injured parties are implemented in this reform plan. So you can see there are propositions for an update for the product liability on the European Union level. But what rests is the same definition of defect. So again, we must decide which safety can we expect from an automatic car. Okay, this was the one regime, the regime about product liability. And now we have a second regime, the regime for liability for artificial intelligence in general. This is a resolution of the EU Parliament from 2020. So it's 2 years older than the proposal for the update for the product liability. The European Union also addressed the question who is responsible if damage was caused by artificial intelligence. And in this proposal, there are two different kinds of AI systems. They make the difference between AI systems at high risk and other AI systems. A system at high risk, there you will have a strict liability. In the other cases, only fault-based liability. Who is responsible? The operator of the system. Of course, in the proposal, there are long definitions. Who is the operator, back-end operator, etc. When we look at autonomous driving, it would be most probably a system at high risk because of autonomous driving. You will have the risk that many persons are injured or killed. You have the problem that the victims are random because it could be passengers who are going by. So most probably autonomous driving would fall under the regime of strict liability. Who is the operator? The operator could be, for example, if it's the Geneva transport system who's using the autonomous buses, they could be the operator, but also the producer of the autonomous car who is still in control of the car because of updates and other things could be considered as an operator. The advantage for the victim is in this case that the defect of the product is not a condition for the liability. So according to this, AI is causing a damage, the operator is liable, and fault or defect is not a condition. So here you could actually say there is a very high protection of the victim. But this liability for AI won't be applied in the case product liability is applied, because the product liability directive is exclusive. So when we have a product as autonomous car, the product liability regime will apply, and there you need a defect for holding the producer responsible. So this proposal for the liability for AI in general, the resolution of the Parliament from 2020, actually doesn't play a role, because in most cases you can always apply the product liability law. Okay, so this was the chapter about the proposals, initiatives on the EU level. Just to, before coming to an end, small remarks, what is happening in countries which are not members of the European Union. And here I have a small example about Switzerland. And here at the moment, the government does not have any projects to reform the liability law because of autonomous driving. And I really like the reason the government was giving for their non-doing, because they prefer to rest neutral. Neutral when it comes to the technologies. They're really using the word technologieneutral, in the sense that the general rules and responsibility, they work very fine, and they don't need a special law for special technologies. So that's why they are neutral on technologies. So we have the Road Traffic Act, which foresees objective liability, strict liability of the keeper, as in the German law. And when it comes to product liability, there is a law in Switzerland which is very, very similar to the European directive from 1985. So here Switzerland would also need an update that software, etc., would be recognized as a product. And a last example from China, Shenzhen, they have a Road Traffic Act from 2022, which allows tests of high automation driving. High automation driving, according to this act, means there's a little difference with our level 4, that the driver must take control if needed. So there is still a driver in the car, but not really behind the driving wheel. So what do we see about liability in this law? They say the driver could be liable. If the driver is not liable, it will be the owner of the car or the manager of the car. There was no definition of manager of the car, but I guess it's very similar to the keeper, the Halter in German, like the person who is in charge, taking care of the car, etc. And what I really like in this Chinese law, in the same act, in the Road Traffic Act, they have a rule about product liability. So it's not a different regime in a different law. It all comes together, and they say in the case of the defect of the car, the producer or the seller must compensate the driver, owner, or manager. So that's in China, it's interesting. If there is a defect of the car, the victim can address the producer, but also the seller. and then the seller can ask compensation to the producer. But in a great difference to the European laws, everything is in the same Road Traffic Act. So we have the two regimes of liability in one law regarding road traffic. Okay, so we are coming to an end. What would be my resume of this talk? Most important, human responsibility first and foremost. Responsibility, of course, legally when it comes to damage liability, but also ethical. And what we can see in the future most probably is a shift from the users and holders responsibility to producers responsibility. Why? If we have driverless cars in the futures, which promise us that the amount of accidents is much lesser than today, they talk about 90%, we will have much more cases where the reason for an accident is the software which was not working. And so product liability might play a huger role than today the liability of the keeper. So thank you very much for your attention. If you have any questions or want to discuss or just have any comments, I'm happy to hear and to get in touch with you. I don't hear anything.
Thank you very much for this very interesting lesson, and also for this presentation, which was extremely clear and also beautiful and amazing. So thank you very much. It was a very precious lesson and the best way to finish this series of seminars. So here we have students in class which are ready for the debate. And so, first of all, I give them the floor, but I have also other curiosities. So after them, I will ask something, and you like to ask anything to a question. I start this question time. No, first of all, I was curious about this because we have the first case in which we have a law which is committed with the problem of the traffic policy. And I think that this solution is extremely interesting because it continues to put the focus of the human being, also considering that the software is not capable to detect everything in the specific situation in which the dilemma is present. So this idea, I think it's very interesting because when we studied many years ago with our philosophers in Bologna, and also you have cited Charles Forley and article, they told me this dilemma is not completely correct because this is a theoretical problem. And in every singular case, you do have many things to consider which are different case by case. And so it's in some ways so artificial to decide to put this into an algorithm because the algorithm has to get the decision in general, but we have to consider any specific case. So I think that this is the best way in order to get out of this dilemma. So to say, we have general rules, but when you face a single driving choice, any tragic choice is different, and we are not capable to predict in detail every possible scenario in this tragic choice. So, what do you think about this? If you agree with this, and also if you have heard any other opinion about this debate, also in Switzerland or in other systems, different system in Europe?
Yeah. Thank you very much for your question. I hope I didn't miss any elements, because sometimes the audio was a little bit interrupted. But if I got it right, what you were saying, you think a programmation is not the best idea because every specific case is different. And your question was about, are there similar discussions in Switzerland?
Yes, exactly. Yeah.
Okay. When it comes to Switzerland, compared to Germany, like before the law in Germany was promulgated, they really created a commission of important jurists from the Constitutional Court, also philosophers. One philosopher who spreads this idea of digital humanism, he's professor in Munich, Nida Rümelin, who was also federal minister before. So this was a commission with very distinguished scholars who have wide experience in this field, and they were working on the resolution for a very intensive time, and they came to concrete results. And when we see the latest declaration of the government in Bern here in Switzerland, they don't want to proact too quickly. So they're, as they say, we will wait and see. We will wait until we have the cars here and to know what actually are the new problems we will have. They don't really want to go forward. So they have not announced to install such a commission. So as far as I'm informed, there are no real projects at the moment. But honestly, I'm not so critique of this Swiss approach, because what is interesting in the legal debate worldwide, I mean, there are so many articles, books written about autonomous driving since years, and this technology in Europe is actually not really there. Like, we have the first minibuses who are doing their tests, etc., and even the German law about the level 4. These cars are not there yet. So we're doing laws for the future for things that doesn't really exist. And this is spectacular, because lawyers, normally they are not so innovative. They don't anticipate what will be the future. Normally judges, they're more reactive. So there comes a new case with a new problem, and they're trying to find the solution according to the principles we have at that moment. So we can really ask, where does all this hype come about? Why do we lawyers love these discussions about tragic choices, etc.? And there's so much energy going into these questions, in spite of the fact that we don't have one single court decision about that yet, in Germany at least. So I think it's you can do the Swiss approach and say, okay, let's keep calm, let's see what is really happening, and let's see if we really need to change our law. Because in the last decades, we have seen in so many other fields that the legislator, they act very quickly. There is a new problem, so they make a new law in a too short time, and then the law has some problems and needs to be changed again. And this is a problem when it comes to the security of law. And I think it's good to have like stable principles, for example, strict liability for the keeper of the car. And if you really trust these principles, you can always stay with the principles and apply them for every individual case. So this to defend the Swiss approach.
Thank you very, very much. Now, I was looking at, we have another question coming from the audience. If you like, you can come, because we have a colleague coming from Romania, which is now in Bologna University, and I give you the floor. Can you hear me?
If you can take the mic a little bit closer and speak louder, that would help.
Yes, that
Yeah.
is not a problem.
Mhm.
So my question is regarding the performance of the autonomous driving systems. And we really have some standards that are used to evaluate this performance of autonomous driving systems. Do they really exist legally, from the legal point of view?
Thank you for your questions. You ask about the performance of the autonomous driving. Performance in the sense of technical performance, or?
Maybe in some way, yes. Regarding, do you know if there are some legal conditions that producers are obligated to have in order
Yeah.
to be declared autonomous?
Yeah. Okay. Yeah. Thank you very much for this question. When you look at the law, the German law, the laws I was citing today, this is the law, the Straßenverkehrsgesetz. And there is a second part to this law, which are the special rules, the more detailed rules for the administration. Straßenverkehrsverordnung in German. And there you can find more detailed information about technical issues. They do precise not only quite a lot of technical conditions the car needs to meet. Yeah. I have sent to Enrico yesterday the law. I can also send you the Straßenverkehrsverordnung if you're interested in it, but I'm afraid there won't be an English translation. But when you want to look into the details, I think this really responds to your question. And I think there is a lot they wrote into that about the legal, the technical conditions of the car.
Okay, thank you very much. Well, I think ChatGPT will help us translate.
Yes.
Now,
That's a good idea, yeah. I will send to Professor MUREDEN the Straßenverkehrsverordnung, and then you can translate a lot with ChatGPT of it.
Thank you very much.
You're welcome.
And also, connecting my question with this, it's very interesting, the idea which you defined the path from the assessment of safety.
Sorry, Enrico, can you hold the microphone a bit closer? That helps. Thank you.
It's very interesting, the idea to pass for the assessment of safety, which is like a portal. So the idea is I assess if this product is safe when it enters into the market, and after I do not lose this evolution. From to shift to the idea to a continuous monitoring during this entire cycle of life of the product. So this can be a good way to understand if the standard of the automatic car are really good or not, because we have an assessment which is in some ways artificial. We assess the product before they enter into the market, but we follow it over time. It's perhaps the best way. So this is very interesting to shift toward this new approach. Perhaps we have another question. Perhaps okay. Thank you. Okay. No, the question was again, how we think that also in Switzerland or in the new European law on product liability, this shift toward a life cycle safety will be, we can say, implemented, and how it can be used for us.
Thank you, Enrico. This is a very good point. So what you're actually saying is that the proposal, the shift they are making there to say it's not only the moment when the product was put on the market, but we also have to consider what happens later, should become a general standard, not only because of software, but for all goods. And I can give you an example about German law on product liability, because before the directive came in 1985, the federal court in Germany, they had their own standards of product liability. And one of the standards was actually more severe than the European law, because the German federal court, they actually said that the producer is obliged to control the product after it came into market. So if there are any new findings or any new developments, the producer will be held accountable even later. I think it was a case about fungicide, some chemical liquid you would use to for apple trees, for example, and there was this product combined with other liquids had a special effect, and this special effect was only discovered a couple of years later. And here actually the German federal court said, okay, there is liability of the producer, even though this problem was discovered later, and later than the product was put into market. So what I want to say, this idea that only the moment when the product comes to place is the decisive moment, is a specific idea of the European Directive of 1985. So if the real aim is consumer protection, you can always expand the producer liability and saying, yes, we need to look into the development of the product. And maybe the European legislator made a mistake in 1985, because a similar problem is also the risk of development, risque de développement, which is also excluded with the product liability in 1985. So there's another point where the development of the product, new findings actually don't lead to a product producer liability. So maybe thanks to software and the latest evolution, the European legislator make one step back to protect the consumers better. Mm-hmm. I don't hear.
Yes, the last question from Professor Département, which teaches with me at the Motor Vehicle University in Modena and Bologna.
Mm-hmm.
I hope you can hear me.
If you speak a little bit louder, that would help.
Okay. So, first of all, thank you for your presentation, which was really interesting. My question would be about another shift that we are witnessing with Professor MUREDEN while having this series of seminaries with also many experts coming from the car manufacturers. Mm-hmm. And they are all telling us that they are preparing for a market in which car manufacturers will keep the property of the car, yeah, and will sell mobility as a service. Mm-hmm. So I was wondering if in your studies, the legal experience in Switzerland, you are taking into consideration also this change in the market, which may also influence the liability criteria, because the rule we have in Italy makes also the owner liable for car accident, which in a market which all car manufacturers are owners of their own cars, maybe will help us designing a brand new scenario also from a liability point of view.
Mhm. Thank you very much for this question. This is very interesting. So in Italy, according to the Road Traffic Act, it's the owner. It's not the keeper or the manager who is responsible.
Both. We have both them liable.
Okay, because the situation here in Switzerland is, as in Germany, it's the strict liability of the keeper, which is not the owner. So because already today, you know, there are so many concepts of leasing, etc. Very often the person who's actually using the car is not the owner anymore. So you could actually say this a concept of the person using the car is the owner is a little bit old. That's Roman times. Today we have many forms when the person using it is not the owner anymore. So this is the reason why in the German law and also in the Swiss law, they don't refer to the owner, they refer to the keeper. So of course, when you have now in Italy a law which in the Road Traffic Act which says that the owner is liable, there the original idea I think is changing. When I talk about Switzerland and Germany, we will also see a shift because, of course, these new ideas of mobility, which will shape the mobility in towns in the next decades, they exist. And we expect also there are some studies saying, okay, it's like car sharing, there's the autonomous taxi, you can use it and then you give it away. And the producer, I don't know, BMW or something, they produce the car and then they also offer the service mobility. This, of course, plays a role for the questions of liability for different reasons. First of all, the liability regarding the Road Traffic Act may change because if you consider that in this case, the producer offering the service mobility is also the keeper of the car. So according to this regime, he will have a strict liability if he is considered as the keeper. But the second regime, according to the product liability, will also make the producer accountable, liable in the case of a defect. And when we look at the proposal for artificial intelligence in general, we will also have the producer accountable under this regime because he will be the operator. He will be the back-end operator and the front-end operator. Because front-end operator, he's like serving, offering the mobility services. So what will play definitely a lesser role is the responsibility of the individual who's actually using the service of mobility, because the person using the car, inside the car, won't be keeper anymore, so there won't be a responsibility according to the Road Traffic Act, and the person won't be considered as a front-end operator. So the individual using this transport service won't be liable in the near future. So we have there a shift. And I think the manufacturers there are aware of the shift. As you said, you were talking to them, and they also want this reform when it comes to mobility.
Thank you very much. If there are not any other questions from the students, can finished this lesson, this cycle of seminars, and we hope very, very much to continue this and perhaps to be all together in Bologna in person very, very soon. I hope. Vi mandiamo un saluto dalla Sala delle Armi, bellissima, che conosci, e speriamo di averti qui molto presto. Poi forse ci vediamo prima anche in qualche altro posto in Italia.
Grazie, grazie, con piacere, sì.
Ok.
Ok.
Tutti vi salutano con grande affetto e complimenti. Questa presentazione era anche bellissima dal punto di vista grafico, oltre che interessantissima, davvero spettacolare. Grazie, grazie davvero.
Grazie a voi, grazie a te Enrico e a molto presto, spero. Grazie anche per le domande e la partecipazione.